If you're here, you may be wondering, what in the world is posthumous assisted reproduction? And you may be saying to yourself, posthumous? Like occurring after the death of someone posthumous? Can somebody really become a parent or reproduce after they're dead? Well, maybe. Stick around and I'll explain what I mean. Hello, I'm Corlandos Scott, an assisted reproduction attorney in Los Angeles, and that simply means that my practice revolves around helping people grow their families through assisted reproductive technologies. Well, in today's episode, we're going to talk about what is posthumous assisted reproduction. We'll talk about the legal implications of posthumous assisted reproduction, and we'll cover some ethical issues around posthumous assisted reproduction. Let's get to it. So what is posthumous assisted reproduction? Well, other than being a mouthful, let's first define the word posthumous. Posthumous simply means occurring, awarded, or appearing after the death of the originator. Posthumous reproduction occurs when a child is born after one or more of the biological parents have died. By the way, fun fact, Sir Isaac Newton, the mathematician who broke down the whole gravity thing for us, he was born posthumously, and his father was illiterate. Talk about doing the family proud. Okay, anyway, back to it. If you're watching this video, you probably already have a basic handle on what is assistive reproductive technologies, or ART as we call it. It's the science and medicine behind the technologies that help us overcome infertility in order to have a baby. So when we put the two together, posthumous and ART, we see that posthumous assisted reproduction is the process where assisted reproduction is used to establish pregnancy and produce genetic offspring after the death of the parent or parents. But before we dive headfirst into it, let's look at some history. Postmortem, or after death, conception by artificial insemination is not something that's terribly new. We've been accomplishing this since the 1950s using cryopreserved, or frozen as they call it, sperm. Now, this was initially brought about because it was offered to men in high-risk professions like soldiers and astronauts. The idea was this: honey, thanks for volunteering to go walk on the moon, but what if you're attacked by aliens or burned up on re-entry? How will I have a baby? And the answer was, don't worry, hun. I've frozen some spermatozoa that you can use and thaw it out and have Junior, and it'll be just fine. Something like that. Then we got a little more sophisticated, and in 1980, we had the first postmortem sperm retrieval. See, sperm can remain viable inside a dead man's body for 24 hours after his death. And actually, motile sperm has even been successfully obtained as late as 36 hours after death. Mind-blowing. But it's not just a man's party. With the help of assisted reproduction, men are not alone in being able to reproduce posthumously. Women are just as able. All right, take this hypothetical for instance. A woman commits to having children only to subsequently be diagnosed with cancer. She decides to undergo fertility treatment in order to have her eggs retrieved before she starts the chemotherapy sessions. The extracted eggs are fertilized with her husband's sperm. Now, the plan is for the woman to transfer the embryos to her own uterus after she completes the cancer treatment. Unfortunately, she doesn't survive the cancer, but we still have the embryos that were created with her eggs. So that opens the door to several questions. What will happen to the frozen embryos? Should her husband, her parents, or even her friends be given custody of the embryos in order to carry out her wishes to have a child? Well, what would be the consequences if she had signed a consent form leaving the embryos in the care of her husband with explicit instructions for him to hire a surrogate to carry their child? Should her wishes to reproduce posthumously be granted? These are all good questions. Let's start with some of the legal implications of posthumous assisted reproduction. There are a number of legal issues ranging from consent to citizenship to inheritance or estate law. Now, most countries have no laws really that directly address both the retrieval and the use of a dead person's gametes or sperm or eggs. Then there are those countries that do address it and address it very strongly. For instance, German law explicitly forbids the use of gametes of a dead person for artificial insemination. And even the medical practitioner who violates this may be subject to 3 years in prison or a fine. Now, in the US, we address this on a state level. One of the questions is, who has the right to use the deceased person's genetic material? Now, in most states, the spouse of a deceased person is the only one allowed to do it. But marriage alone doesn't give you a green light. There are some states that require, prior to death, that the deceased person must have given consent to use his or her gametes posthumously. But the other big ticket issue around posthumous assisted reproduction is whether a posthumously born child can inherit from the deceased. After all, if the parent was dead when the child was born, the child never really depended on that dead parent for subsistence. But let's take Massachusetts, for instance. In Massachusetts, a court had to decide if a married man and woman arranged for sperm to be withdrawn from the husband for the sole purpose of artificially impregnating the wife, and the woman is impregnated with that sperm after the man, her husband, has died, will the child resulting from that pregnancy enjoy the inheritance rights of natural children under Massachusetts law? That's a mouthful. But Massachusetts broke it down, and they decided that in order for that child who was born after the father passed away to inherit, 3 things had to be present. Number 1, a surviving parent or legal representative had to show genetic relationship. Number 2, the deceased parent must have affirmatively consented to the posthumous reproduction, and they had to consent to support any resulting child. And third, the request for the child inheriting had to be brought before the court within a certain time period. Now, New York came up with a similar criteria for whether a posthumous child could inherit from the dead parent. They said it like this. They said, number 1, there had to be a written document indicating that the deceased parent intended to have his or her reproductive material used to conceive a child, and that document couldn't be more than 7 years old when the person died. Can you believe that? It's like, you may change your mind after year 7 or so. Second, New York said that the surviving spouse must be authorized to make decisions about the deceased person's genetic material. Number 3, the court said that the documents must be filed with the court within the county of residency of the dead person. And number 4, the genetic child must be in utero, basically means must be, in the belly baking, no later than 2 years after the genetic person's death, or they have to be born no later than 33 months after the genetic parent's death. So one of the most important factors for posthumous fathers, at least, is when the sperm was retrieved. Now, based on what we just discussed, there's a pretty solid framework for what happens when the sperm is retrieved and stored prior to the father's death. But what about sperm retrieved after the father has died? Remember, sperm remains viable for 24, even up to 36 hours after death. Well, here's a couple really interesting cases. An Iowa man named Daniel was in a severe motorcycle accident, and he later became brain dead. And plot twist, he was engaged. So his fiancée requested from Daniel's parents to have his sperm extracted for her to use in starting her family. The parents later agreed to do it, but the hospital refused to perform that procedure without a court order. If there's anybody or any professional group that's wary of lawsuits, it's definitely doctors and hospitals. And that hospital said, we're not getting anywhere close to this without the court saying it's okay. So the fiancée ended up getting what she wanted. So the court authorized the postmortem sperm retrieval by stating that the gifting of sperm can be made by the donor, or if the donor didn't refuse to make the gift, by the donor's parents following the donor's death. So this also opened the door to allow the next of kin to consent to the retrieval of organs and tissues after death, unless there was evidence that the deceased person would not have consented. Here's another interesting case. There was a similar case in New York where a court granted the parents of a dead soldier the right to retrieve and use his sperm in order to fulfill what they described as their son's lifelong desire to have children and continue the family name. Now, if you've never thought about this topic, which who really has, then these cases probably seem like pretty unbelievable stuff. Which brings us to the ethical issues. But before we go there, do me a favor and just smash that like button so YouTube knows to share this video with other people. And while you're down there hanging out around that like button, go ahead and subscribe and click the little bell so that you get notified when I release new episodes. So what are the ethical considerations for this novel idea of posthumous assisted reproduction? Well, consent for sure is at the top of that list. The main idea there is that if posthumous conception occurs without the deceased person's consent, then it really on a human rights level deprives the individual of the opportunity to quote unquote be the author of a significant chapter in his or her life or afterlife. There's also the issue of the rights of the deceased. We want to make sure that we respect the deceased person's wishes. So one of the things that courts do is make a determination of the wishes of the deceased. Did they want to have children posthumously? Also, we have to consider the best interests of the posthumously conceived child. I mean, I guess it worked out for Sir Isaac Newton, but we have to give this some thought. This is why the Massachusetts court requires things like a genetic connection to the surviving parent, and also knowledge that the deceased person consented to support the child. At the end of the day, if you want to continue your or your family member's lineage, even after death, the best thing to do is plan for it now. One of the things that I prepare for a number of my clients is called a reproductive estate plan that covers issues just like this. So if you need help getting one of those in place, don't hesitate to reach out to me. You can contact me by simply clicking the link in the description and you'll automatically start a chat with me. Above all, just make sure you get the necessary documents and paperwork in order, the same way you get your taxes prepared and filed. I mean, as they say, nothing is certain except death and taxes. Or maybe these aren't so certain anymore. I could have sworn, but anyway, see you in the next episode.